Karen Whitfield changed the locks on my front door while I was at my mother's funeral. Not a metaphor, a literal new deadbolt. Still had the installation sticker on the faceplate, and a violation notice taped to the door citing a wooden sign my dying mother had made me by hand. I read the notice once, folded it, put it in my jacket pocket, and I thought, she has no idea how badly she just miscalculated. Not because I was going to scream at her, not because I was going to file something in the morning out of raw anger, but because I've spent 23 years as a combat engineer, and the first thing that training burns into you, deeper than any technique, deeper than any tool, is this. The most dangerous response to a threat is the one the enemy never sees coming, because they're too busy believing they already won. Karen had just locked me out of my own house on the worst week of my life. She'd left a paper trail doing it. She'd left a timestamp. She'd left her name on the authorization line of a document that cited a statute she clearly hadn't read. I didn't knock on a neighbor's door that night. I didn't call the HOA emergency line. I walked back to my truck, sat in the dark 50 yards from my own front door, and I started counting. Not seconds, evidence. How confident does someone have to be in their own authority before they sign their name to something they haven't actually checked? My name is Marcus Webb. I'm 48 years old. I do infrastructure consulting for government facilities, blast-resistant design, structural hardening, the kind of work where a miscalculation doesn't mean a cost overrun. It means a building doesn't survive what it was built to survive. Before that, 23 years in the Army Corps of Engineers, 2 deployments, more controlled demolitions than I can count from memory. I moved to Stonegate Commons 6 years ago, bought the house outright. No mortgage, no HOA financing arrangement, no leverage point anyone could use against me, which matters more than it sounds, and I'll come back to that. The neighborhood is clean, well kept, the kind of place where people wave from driveways and actually mean it. I liked that. After years of bases and deployments in transitional housing, I wanted something that felt permanent, something with roots. My mother's sign went up the first week. Webb family established 1987. She'd painted it herself on a piece of reclaimed barnwood, block letters in forest green, the year my father and she had built the family into something worth naming. She gave it to me when I bought the house, said every home needs to know what it's carrying. I hung it beside the garage door on a hand-forged bracket, level to the millimeter, because that's how I do things. My daily rhythm is not complicated. I'm up at 5, coffee black. I review whatever project specs came in overnight, usually from a federal contractor in Virginia or a facilities manager in New Mexico. I run 3 miles. I come home, shower, work until early afternoon. Twice a week, I drive to a range outside Scottsdale, not because I'm tense, but because precision under repetition is a discipline I don't want to lose. Evenings, I cook, I read, I keep my yard exactly to HOA standard, not because I'm afraid of citations, but because I was raised to maintain what's yours. I am not a difficult neighbor. I have never missed a dues payment. I have never had a loud party, a junk car in the driveway, a complaint filed against me that had any merit. My file with Stonegate Commons HOA, before Karen Whitfield became president 3 years ago, was clean. 36 pages of nothing. Routine correspondence, a paint color approval, 1 question about fence height that I resolved in a single email exchange. I say all of this not to establish that I'm a good person. I say it because it matters to the architecture of what Karen built against me. And what she never understood is that when you decide to target someone, the first thing you should do is find out exactly who they are. She never did that. There's a principle I learned early in the Corps that most people never formalize, but almost everyone eventually figures out the hard way. The worst thing you can do when someone makes a mistake is correct them too soon. Not because you want them to suffer, because if you move the moment you see the error, they learn just enough to stop, to retreat, to regroup, to find a smarter angle. But if you wait, if you let the mistake breathe and develop and compound, what you end up with isn't just one wrong move. You end up with a pattern. And a pattern is something an arbitrator can follow, a judge can follow. A room full of homeowners can follow. A detective can follow. One wrong move is a dispute. A pattern is a case. I don't consider myself a patient man by nature. I consider myself a disciplined one, which is different. Patience implies you're waiting for something to happen. Discipline means you've already decided what the right action is, and you're holding it until the moment it lands with maximum effect. In demolition work, timing isn't a courtesy. It's the difference between a controlled collapse and a catastrophe. You don't pull the charge when you're ready. You pull it when the structure has no remaining support in the right places. I also believe genuinely that people deserve the opportunity to stop themselves, not because I'm generous, though I try to be, but because it matters for what comes after. If someone is warned and continues anyway, that changes the moral and legal weight of every subsequent action they take. It transforms an error into a choice, and choices carry consequences in ways that errors sometimes don't. Karen had already made her error the night I came home to a new lock and a folded notice in my pocket. What I didn't know yet was whether it was an isolated act of arrogance or something with deeper roots. Those are two entirely different problems. One requires a complaint and a firm conversation. The other requires documentation, patience, and the willingness to build something she can't dismantle later with an apology or a personnel change on the HOA board. I've seen what happens when people in small positions of authority start believing the position is the same thing as the right. I've seen it on bases, in contracting disputes, in municipalities where one person with a clipboard and a title decides the rules apply to everyone except themselves. It always ends the same way. Not because someone eventually hits back harder, but because the accumulation of their own decisions becomes too heavy to carry. The question I sat with that night, in the dark, outside my own front door, wasn't, "What do I do about Karen?" It was, "What kind of problem is Karen, actually?" The answer to that would determine everything. When someone wrongs you and you don't react, is that weakness, or is that the first move in a game they don't know you're already playing? Let me tell you what Karen actually touched when she hung that new deadbolt on my door. Not a compliance issue, not a sign violation. Not some abstract HOA dispute that could be resolved with a fine schedule and a form letter. She touched the last physical thing my mother ever made with her hands. My mother spent the final 18 months of her life with a diagnosis that took things from her incrementally. First, the long walks, then the stairs, then eventually the kitchen, which she loved more than almost any room she'd ever lived in. But she had a workbench in the garage, low enough that she could reach it from a stool. And in the last summer she was well enough to do it, she found a piece of barnwood from a demolition site I'd brought her. She'd asked for it specifically, said she liked wood that had already held something up, and she painted that sign by hand, block letters, forest green. The year my father and she had decided to stop being two people and start being a family. She shipped it to me when I closed on the house. No note, just the sign, wrapped in a moving blanket, and a small piece of masking tape on the back that said, "For your wall." I hung it the first week, level to the millimeter. I've looked at it every morning since. When Karen sent the first violation notice, the one that arrived while I was making hospice arrangements, it cited the sign as an unapproved exterior display inconsistent with community aesthetic standards. The second notice arrived 2 days later. The third came while I was boarding a plane to Georgia for a military funeral. She didn't know any of that. She didn't ask. That's the part that settled something in me. Not the lock, not the violation notices. The fact that Karen Whitfield had looked at a hand-painted sign on the side of a house and seen a compliance problem, had sent 3 notices about it inside a week, without once considering that there might be a human being on the other side of that door going through something she couldn't process on a clipboard. She reduced my mother's last gift to a line item. And then she changed my locks while I buried her. That's what was at stake. Not property rights, not HOA bylaws, something that can't be replaced, being treated as though it barely existed. I needed Karen to answer for the right thing, all of it, not just the lock. The morning after I slept in my truck, I called a locksmith before 6 a.m., had my original hardware restored by 7:15, paid cash, kept the invoice, noted the timestamp. Then I made coffee and started reading. Not the violation notices. I'd already read those. I went deeper. I pulled the Stonegate Commons HOA governing documents from the county recorder's website. CC&RS, bylaws, board meeting minutes going back 4 years. The full archive. It took most of the morning. I took notes in a yellow legal pad I keep for project documentation, the same way I'd log a site assessment. Dates on the left margin, source citations on the right, observations in the middle column. 2 hours in, I found the first thing that didn't fit. The lock modification Karen had authorized cited an HOA provision allowing emergency access to properties presenting imminent safety or structural hazards. The violation notice attached to my door listed the hazard as unapproved exterior display, a painted wooden sign Karen had used an emergency safety provision, the kind meant for burst pipes and gas leaks and structural failures, to justify changing the locks on an occupied home because she didn't like a piece of barnwood beside the garage. That wasn't a paperwork error. That was a deliberate misapplication of authority. Someone had looked at the provision, understood what it was for, and used it anyway for something entirely different, betting that the homeowner either wouldn't read the fine print or wouldn't know what to do if they did. I wrote that down, underlined it twice. Then I kept reading. Board meeting minutes are dry documents. Most people never look at them, but if you read enough of them in sequence, a pattern can surface the way a crack surfaces in a load-bearing wall, invisible until you know what stress looks like, then suddenly impossible to miss. I found it in the minutes from 14 months prior. A motion, approved 3-1, authorizing the HOA management company to coordinate expedited compliance enforcement on properties with chronic, unresolved violations. The motion had been introduced by Karen. The dissenting vote belonged to a board member named Paul Ochoa, who had resigned the following month. His resignation letter, also in the public record, cited concerns about enforcement methodology and conflicts of interest without elaborating further. I sat with that for a long time. Conflicts of interest. From a board member who quit 1 month after losing a 3-1 vote on an enforcement expansion motion that Karen had personally introduced. I opened a new browser tab and searched the Arizona Corporation Commission database. It took 4 minutes to find what I was looking for. Whitfield Property Group, LLC. Registered owner, Karen A. Whitfield. Date of formation, 31 months ago. Business classification, residential real estate acquisition and resale. I set my coffee down. This wasn't a neighbor with a clipboard and a grudge. This was something with structure, something that had been running for a while, quietly, on the assumption that nobody would ever sit down and read the minutes. How many people mistake a system for a person and only realize there's architecture behind the cruelty when it's already too late to stop it cleanly? I could have moved fast. I want to be honest about that. By the end of that first week, I had enough to file a formal complaint with the Arizona Department of Real Estate, enough to contact an attorney about the illegal lock modification, and enough to walk into an HOA board meeting and make Karen Whitfield deeply uncomfortable in front of her own constituents. The Arizona statute on lock modifications was unambiguous. The misapplication of the emergency access provision was documented in her own paperwork. The existence of Whitfield Property Group was public record. I had options, real ones, early ones. I chose not to use them yet, partly because one complaint filed too soon becomes a he said, she said that Karen could weather with a prepared apology and a procedural correction. She'd say it was an administrative oversight. She'd say the management company acted without full authorization. She'd revise the policy, issue a statement to residents, and emerge from it looking like someone who takes accountability seriously. The lock incident would become a footnote. Whatever she was running underneath the surface would go quiet for a year, maybe 2, and then resume once the attention passed. I'd seen that before. Not in HOAs, in contracting disputes, in base command structures, in situations where the person with positional authority gets one warning and uses it to reorganize rather than stop. The behavior doesn't end, it adapts. But there was a second reason, more personal, that I didn't want to examine too closely at the time, but couldn't entirely avoid. I wanted her to know I knew. Not in a confrontational way, not a threat, just a moment where she'd have to sit across from me and understand that the person she'd chosen to target had read everything she'd filed, understood exactly what provisions she'd abused, and was still standing in his driveway looking calm. I wanted to see what she did with that information, whether she'd pull back or push harder, because that answer would tell me everything about whether this was opportunistic or compulsive. So I requested a meeting, formal, through the HOA management company's contact portal. Subject line: lock modification on my property, request for documentation, professional, measured. I asked for the emergency authorization paperwork, the safety hazard assessment, and the name of the licensed contractor who had performed the modification. The management company's response arrived in 48 hours. They had no record of an emergency authorization. They had no safety assessment on file. The contractor name they provided turned out to be a handyman Karen had used before, who held no relevant license. I forwarded the response to my legal pad. New page. Wrote the date at the top. Then I called Karen directly. She answered on the second ring, confident, the way people answer when they don't expect the call to be difficult. I told her I'd received the management company's response, that the documentation appeared incomplete, and that I wanted to give her an opportunity to correct the record before I pursued the matter further. There was a pause. Then she said, "Mr. Webb, I don't think you understand how this community operates." I wrote that down too, word for word. If someone shows you exactly who they are in the first 30 seconds of a difficult conversation, is it their fault or yours when you hold them to it later? After that phone call, Karen sent 3 things in rapid succession. First, a formal written notice reaffirming the original sign violation and adding a new one. Failure to maintain approved exterior hardware, which was her way of citing the fact that I'd had my original locks restored. She had turned my act of recovering access to my own home into a second violation. Second, an email to the full HOA resident list describing a recent enforcement action taken against a property with persistent compliance issues, without naming me directly, but including enough detail, street address quadrant, violation category, duration of non-response, that anyone in Stonegate Commons who wanted to connect the dots could do so in under a minute. Third, a handwritten note left in my physical mailbox. No envelope, just a folded piece of HOA letterhead that said, "Community standards exist to protect everyone's investment. I hope you'll reconsider your approach." I read all 3 in sequence, sitting at my kitchen table with my legal pad open. What struck me wasn't the aggression, it was the volume. 3 separate communications in less than 72 hours across 3 different channels after a single measured phone call in which I had done nothing but ask for documentation. Karen wasn't responding to a threat. She was escalating against the absence of submission. The moment I failed to fold quietly, she turned up the pressure. Publicly, in writing, with her name attached to all of it. A person who understood they were on uncertain legal ground would have gone quiet, would have consulted someone, would have at minimum stopped generating paper. Karen generated paper the way some people generate noise when they're nervous, reflexively, compulsively, as though the volume of documentation proved the legitimacy of her position. It didn't. It proved the opposite. Every letter was a timestamp. Every email was a distribution record. Every notice was a signed statement of intent that I hadn't asked for and she hadn't needed to produce. She was building my case for me. I let her. The second week, I stopped reacting entirely and started building. First thing I did was call the Arizona Department of Real Estate and request the public complaint history for Whitfield Property Group, LLC. The clerk told me processing would take 5 to 7 business days. I gave her my fax number. Yes, I still have a fax number. Federal contracting requires it. And thanked her. Then I drove to the Maricopa County Recorder's Office and pulled property transaction records for Stonegate Commons going back 5 years. Not just Karen's purchases, every sale, Every transfer, every deed recorded within the subdivision boundaries. I asked for certified copies of 7 specific transactions that had caught my attention in the digital index. The clerk printed them while I waited. I paid the copying fee in cash and kept the receipt. That evening, I laid everything flat on my dining room table. Sales records on the left. HOA enforcement notices, pulled from the public board minutes, across the middle. Violation histories for each property on the right. I used a yellow highlighter for dates, red pen for names. I work better with paper than screens when I'm looking for pattern rather than data. It took about 90 minutes before the shape of it became undeniable. 7 properties, 7 households that had received aggressive, escalating enforcement actions from Karen's HOA presidency. 6 of those had sold within 14 months of the enforcement campaign beginning. 5 of those 6 sales had closed at between 11 and 19% below the neighborhood's average price per square foot during the same period. 4 of those 5 below-market sales had been purchased, directly or through a single intermediary LLC, by Whitfield Property Group. I sat with that for a long time. Then I opened my laptop and drafted a single email to each of the 3 neighbors I'd spoken to casually over the years. People I knew well enough to trust, not well enough to have told any of this to yet. I kept it short. Asked if they'd be willing to have a private conversation about their experience with HOA enforcement in the past few years. Mentioned nothing about what I'd found, just asked the question. All 3 responded within 24 hours. All 3 said yes. I added their names to my legal pad under a new heading, Witnesses. Not because I was going to need them immediately, because when this opened up publicly, and I was increasingly certain it would, I wanted people who could speak from their own experience, not just from documents I'd assembled. The difference between a file and a case is human voices. While I was building, Karen was accelerating. The 3rd notice arrived on a Thursday. This one citing failure to comply with exterior hardware restoration requirements and adding a daily fine of $35 retroactive to the date of my locksmith visit. She had calculated the accrued total in bold at the bottom of the page. $455, due within 10 business days or subject to lien filing. A lien on my house for changing my own locks back after she had changed them illegally. I photographed the notice, front and back, time-stamped, filed it behind the others in a manila folder I'd labeled with nothing but a date range. Then I called the HOA management company and asked, very calmly, for the specific bylaw provision authorizing daily fines for hardware non-compliance and the board resolution approving the fine schedule. The property manager, a tired-sounding man named Gerald, who I'd spoken to twice before, put me on hold for 4 minutes. When he came back, he told me the fine schedule had been approved by a board vote 11 months prior. I asked for the meeting minutes reflecting that vote. He said he'd send them. They arrived the next morning. I read them twice. The vote had been 3-1. The dissenting vote, again, was Paul Ochoa, the same board member who had resigned the month after the enforcement expansion motion. In the minutes, his objection was recorded in a single line. Board member Ochoa noted concern that the proposed fine structure had not been reviewed by HOA legal counsel prior to the vote. Karen had pushed through a fine schedule without legal review. Then she'd applied it retroactively to a violation she had created by changing my locks without authorization. The architecture of it was almost elegant in a grim way. Every new fine increased the financial pressure. Enough pressure, and a homeowner starts making decisions they wouldn't otherwise make. Selling fast, selling cheap, taking the first offer that makes the notices stop. I thought about the 4 families whose sales had closed below market value, wondered how many of them had received a similar stack of notices, wondered how many had simply run out of endurance. I added Gerald's name to my legal pad, not as a target, as a potential witness who didn't yet know what he'd been part of. The HOA board meeting that month was held on a Wednesday evening in the clubhouse. A beige room with folding chairs, a projection screen nobody ever used, and fluorescent lighting that made everyone look slightly unwell. I arrived 7 minutes early, took a seat in the 3rd row, center, set my legal pad on my knee, pen uncapped, and waited. Karen opened the meeting with the confidence of someone who had never once been seriously challenged in that room. She moved through the agenda items: landscaping contract renewal, pool maintenance schedule, gate keypad replacement, with the brisk efficiency of a person who mistakes procedural fluency for actual authority. The other two board members nodded at appropriate intervals. The dozen or so residents present scrolled phones or stared at the middle distance. When she reached new business, she looked up and said, without preamble, "I'd like to address the recent compliance situation on Cambria Court for the benefit of residents who may have questions." She didn't look at me when she said it, which told me she'd thought about whether to look at me and decided not to. She described the situation in broad terms: a homeowner with multiple unresolved violations, an unauthorized modification to HOA-controlled exterior hardware, a pattern of non-cooperation with board requests. Her tone was measured, bureaucratic, the cadence of someone who had rehearsed the framing. She used the word community 4 times in 90 seconds. She never used my name. Then she said it, the sentence that I wrote down verbatim the moment it left her mouth, pressing hard enough into the legal pad that it left an impression on the page beneath. As HOA president, I have full authority to take whatever enforcement steps are necessary to protect the integrity of this community, and I will not be deterred by homeowners who believe the rules don't apply to them. Full authority, whatever steps necessary, will not be deterred. 3 complete declarative public statements made in front of 12 witnesses, recorded in board meeting minutes that would be published to all 340 residents of Stonegate Commons within 72 hours. I didn't respond, didn't raise my hand, didn't shift in my seat. I just finished writing the sentence, capped my pen, and thought about how much harder it is to walk back words you've said out loud in a room full of people than words you've only put in a letter. Karen had just handed me her own testimony. Does a person who announces their authority that loudly actually believe in it? Or are they trying to convince someone in that room, including themselves? 2 days after the board meeting, Karen filed for a formal lien on my property through the HOA's management company. Gerald called to inform me, his voice carrying the particular flatness of a man delivering news he personally disagreed with but had no authority to stop. The lien amount was $630, the accrued daily fines plus a filing fee Karen had apparently approved unilaterally. Gerald read me the figure the way a doctor reads a test result he didn't order and doesn't endorse. I thanked him, asked him to send the filing documentation in writing, and hung up. Then I submitted my permit application to the city of Phoenix. I had been thinking about the door for 10 days. The idea had come to me the same way most engineering solutions come. Not as inspiration, but as logic. Karen needed something to attack, something visible, something she couldn't ignore, something that would give her an excuse to escalate in a way that she would choose herself, on her own timeline, with her own tools. A provocation she'd walk into believing she had every right to be there. The application I submitted was completely legitimate. Residential door replacement, architecturally appropriate dimensions, all required permits pulled in advance, all contractor licenses verified, all HOA aesthetic guidelines met precisely. I included a full specification sheet with my submission: materials, finish, hardware type, color code matched to the existing trim. Karen approved it at the board level without requesting a site review. The approval came back in 4 days with her signature on the authorization line. She had not read the specification sheet carefully. The door I installed the following Saturday took a 6-man crew 8 hours to set. 3 inches of composite steel core with a brushed bronze exterior panel that matched every other door on Cambria Court. A biometric lock with a backup keypad. Electromagnetic deadbolts on a dual redundancy system. Titanium anchor bolts drilled 18 inches into the structural frame at 12-point contact. The whole assembly weighed 840 pounds and was rated for financial institution applications, the same classification used for bank vaults and federal evidence rooms. From the street, standing at normal distance, it looked like every other front door in Stonegate Commons. I had the crew photograph the installation at each stage, time-stamped. I kept the permit on file, the approval signature on file, the full specification sheet, the one Karen had signed off on without reading, on file. Then I called three people. First, Paul Ochoa, the former board member who had resigned citing conflicts of interest. He'd agreed to speak with me 2 weeks prior. We talked for 40 minutes. He told me things that added 4 new pages to my legal pad and confirmed the shape of what I'd been assembling. He hadn't gone to authorities because he hadn't felt he had enough on his own. He did now, with what I had from the county records. He said he'd be willing to provide a written statement. Second, a real estate attorney named Diana Souza, who specialized in HOA disputes and had been recommended to me by a colleague in Tucson. I gave her a summary and asked for a consultation. She had an opening Thursday afternoon. Third, Channel 9 News. I didn't call the station directly. I called a producer I'd met 2 years prior during a story about infrastructure failures in municipal buildings. I told her I had something developing that she might want to know about in advance. She told me to keep her posted. I kept her posted. When someone builds a trap for another person, do they consider that the act of building it might be the most incriminating thing they ever do? The Thursday consultation with Diana Souza lasted 2 hours and 40 minutes. She read through everything I'd brought: the violation notices, the lock modification paperwork, the management company's admission that no emergency authorization existed, the board meeting minutes, the county property records, the Whitfield Property Group registration, the fine schedule approved without legal review, the door permit with Karen's approval signature on the unread specification sheet. She read without interrupting, made occasional notes in the margin of her own legal pad, drank half a cup of coffee that went cold while she was reading. When she finished, she set the last page down and looked at me across the conference table and said, "How long have you been sitting on this?" I told her 3 weeks. She nodded slowly, the way someone nods when a number confirms something they'd already suspected. Then she told me what I had, in plain language, without theatrics. The illegal lock modification alone was actionable under Arizona statute. Civil damages, potential criminal trespass, depending on how the DA characterized the intent. The retroactive fine schedule applied without legal review was likely unenforceable and possibly fraudulent if it could be shown the board knew that and filed the lien anyway. The property transaction pattern, cross-referenced against the enforcement history, was the kind of thing the Arizona Department of Real Estate opened investigations over. If a financial crimes detective looked at the full chain, enforcement campaigns targeting vulnerable households, below-market sales, acquisition by a president-owned LLC. It had the structural profile of a predatory scheme. She used that phrase carefully. Structural profile. Not an accusation. A description of shape. Then she told me about a man named Robert Fenn. Fenn was a retired civil engineer who had lived 3 streets over from me. Widower. He'd received an aggressive enforcement campaign 18 months ago. 7 violations in 11 weeks, a lien filing, a certified letter suggesting he consult a real estate agent about his options given the financial liability accumulating against the property. He'd sold 8 weeks later, 14% below market. Whitfield Property Group had purchased through the intermediary LLC. Diana knew about Fenn because he had come to her office 4 months ago, distressed and uncertain, wanting to understand what had happened to him. She had advised him to document what he remembered and wait. She hadn't had enough to move on alone. She slid his contact information across the table. "He's been waiting," she said quietly. "He just didn't know what he was waiting for." I thought about that on the drive home, about how many people were sitting with pieces of something they couldn't name in houses they'd been pushed out of or nearly pushed out of, not knowing that someone else had the rest of the shape. Some people don't come forward because they're complicit. Some people don't come forward because they're afraid. And some people don't come forward simply because they're alone. And alone feels like not enough. Robert Fenn wasn't alone anymore. The lien filing changed the timeline. Diana had warned me it might. A recorded lien against a property isn't just a fine. It attaches to the title, shows up in any title search, and can block refinancing, a home equity line, or a future sale until it's resolved. For most homeowners, it creates immediate, practical pressure that has nothing to do with whether the underlying violation was legitimate. That's the mechanism. That's why it works. I didn't need to refinance, but the lien was now a matter of public record, which meant anyone pulling my property history could see it. And Karen knew that. The filing wasn't just financial leverage, it was reputational. A lien on your title in a community like Stonegate Commons was the kind of thing that followed a homeowner into every conversation about the neighborhood for years. She had filed it on a Friday. Diana told me Monday morning that if I wanted to contest it before it aged into a harder instrument, I had a narrow window, 30 days from filing date, to submit a formal dispute with supporting documentation to the Maricopa County Superior Court. After 30 days, the process became significantly more involved. I had 19 days left. That compressed everything. The pieces I'd been assembling carefully, methodically, with the patience of someone who believed he had open time, suddenly had a hard edge. I called Robert Fenn that evening. We spoke for an hour. His account was detailed, consistent, and damning. He remembered dates, amounts, the sequence of notices, the name of the real estate agent who had called him unsolicited 3 days after his first lien filing, with a prepared offer from a buyer he'd never met. He still had the voicemail. He still had the certified letter suggesting he consider his options. He had kept everything in a shoebox under his bed because something had told him not to throw it away, even when he didn't know why. I asked him if he'd be willing to submit a sworn affidavit. He said he'd been willing for 4 months. He just hadn't known who to give it to. Diana filed the lien dispute on day 17. The supporting package she submitted to the court ran to 61 pages. My documentation, Fenn's affidavit, Paul Ochoa's written statement, the management company correspondence, the county property records, the fine schedule approved without legal review, and a formal complaint simultaneously filed with the Arizona Department of Real Estate citing the transaction pattern and requesting an investigation into Whitfield Property Group. The same afternoon, I sent a brief, factual email to Karen through the HOA management portal. No accusations, no legal language, just 3 sentences informing her that I had contested the lien, that the supporting documentation had been submitted to the Superior Court, and that she might want to review the filing before the next board meeting. I gave her the case number. I wanted her to look it up. I wanted her to see the shape of what was already in the public record. I wanted her to understand, before Tuesday arrived, that the door on my house was the least of her problems. She looked it up. I know because Gerald called me the next morning, his voice carrying a new quality I hadn't heard before, something between discomfort and relief, like a man who has just realized the building he's been working in has a structural problem that was never his fault. "Mr. Webb," he said carefully, "I think some things are about to become clearer." The Arizona Department of Real Estate responded faster than I expected. Diana had filed the complaint on a Thursday. By the following Tuesday, the same day Karen arrived at my door with a crowbar, I had already received an acknowledgement letter confirming the complaint had been assigned to an investigator and forwarded to the Phoenix Financial Crimes Unit for parallel review. The letter was 2 paragraphs, bureaucratic, bloodless, but the second paragraph contained a name. Detective Alyssa Reyes, Financial Crimes Unit, Phoenix PD. Contact information provided. Parties with relevant documentation were invited to reach out directly. I called Detective Reyes that afternoon. She had already reviewed the complaint filing. She asked me 4 questions, precise and sequential, the way someone asks questions when they're confirming a shape they've already begun to see, rather than searching for one. How many properties? What time span? Whether the acquisition entity had changed names or structures during the period. Whether I had the intermediary LLC documentation. I had all of it. She asked me to come in Thursday with the full file. I brought 68 pages, organized chronologically, tabbed by category, enforcement records, property transactions, corporate registrations, witness statements, financial timeline. I had built it the way I'd build a site assessment report. Nothing included that wasn't sourced, nothing sourced that wasn't verified. Every inference labeled as inference rather than fact. Detective Reyes spent 40 minutes with it while I sat across from her in a conference room that smelled of bad coffee and old carpet. She turned pages the way experienced investigators turn pages, not reading every word, but checking dates, cross-referencing names, pausing at the places where 2 separate threads met at the same point. She stopped twice, made notes, stopped a third time at the property transaction timeline, and looked up at me. 9 families, she said. It wasn't a question. That I can document, I said. There may be more. She nodded, closed the file, told me the Financial Crimes Unit would be opening a formal investigation, told me not to discuss the specifics with anyone outside of my attorney. Then she asked one more question, almost as an afterthought, in the tone of someone confirming a logistical detail. You mentioned she's planning to access your property on Tuesday? I told her what I knew. Karen had sent a final notice the previous Friday, hand-delivered this time, which was new, citing the door as an unapproved structural modification, despite the fact that she had personally signed the permit approval. The notice stated that an HOA inspector would be conducting an on-site compliance assessment on Tuesday morning, and that access to the exterior door hardware would be required. I had called the permit office to confirm, once more, that everything was fully in order. It was. I had the permit. I had the approval signature. I had the full specification sheet she hadn't read before signing. Detective Reyes looked at me for a moment. "Would you have any objection," she said carefully, "to me being in the vicinity on Tuesday morning?" I told her I had no objection whatsoever. That evening, I called the Channel 9 producer, told her Tuesday, told her Cambria Court, told her to bring a camera operator and arrive by 9:45 because things would likely become interesting shortly after 10. She asked, what kind of interesting? I told her, the kind that doesn't require narration. When every piece finally locks into place, not because you forced it, but because the other person put each one there themselves, what does that feel like? Karen arrived at 9:58. I know the exact time because I was standing at my front window with coffee, watching Cambria Court the way you watch a weather system you've been tracking for weeks finally make landfall. The morning was clean and bright, the kind of Arizona October morning that feels apologetic after summer. Cool air, hard light, shadows still long across the driveways. She came in her white Lexus, parked 2 houses down rather than in front of mine, which told me she'd thought about optics. She was dressed for authority, blazer, dark slacks, the HOA lanyard she wore to board meetings. She had a clipboard. She always had a clipboard. The man she brought was introduced when he spoke later as a certified inspector. He was carrying a tablet and wearing a polo shirt with no identifying insignia. His name, I would learn within the hour, was David Whitfield, Karen's brother-in-law. He held a general contractor's license that had been inactive for 14 months and had no certification of any kind relevant to structural compliance assessment. The third person was someone I hadn't anticipated. A man in his 30s with the particular posture of someone trying to look more official than he is, carrying a crowbar loosely at his side, the way people carry tools they intend to use as props rather than instruments. Karen had apparently decided that visible equipment would reinforce the legitimacy of the visit. I watched all 3 of them walk up my front path. I did not open the door. Karen knocked twice, announced herself as HOA president conducting a compliance inspection, and informed me that failure to provide access would result in additional violations and escalated enforcement action. Her voice carried the practiced firmness of someone who had done this before and expected it to work the same way it always had. I let 30 seconds pass. Then I opened the door and stood in the frame. I didn't say anything immediately. I let her see that I wasn't flustered, wasn't angry, wasn't scrambling. Just standing in my doorway on a Tuesday morning, coffee in hand, looking at 3 people on my front step like I'd been expecting exactly this at exactly this time, and found it neither surprising nor particularly concerning. Karen spoke first, cited the violation notice, cited her authority as HOA president, stated that the door installation represented an unapproved structural modification requiring immediate inspection, used the word authority twice in 4 sentences. Then the man with the crowbar stepped forward and put it against the door frame. The crowbar skipped off the brushed bronze panel with a sound like a coin dropped on a tile floor, a faint scratch in the frame, nothing more. 840 pounds of composite steel, titanium anchor bolts drilled 18 inches into structural framing, electromagnetic deadbolts on dual redundancy systems. It didn't move. didn't flex, didn't register the attempt in any meaningful way. The man looked at the crowbar, then at the door, then at Karen. Karen looked at the door. For just a moment, 3, maybe 4 seconds, her face did something I hadn't seen it do in any board meeting or phone call or notice delivery. It lost its certainty. Not dramatically, not a collapse, just a small, involuntary recalibration. The expression of someone who has arrived somewhere expecting to find one thing and found something else entirely. That was the moment the Channel 9 crew stepped out of the car they'd been sitting in, 4 houses down, and started walking toward us with a camera on a shoulder rig. Karen saw them. She turned back to me, and I watched her make the worst decision available to her in that moment. The decision to keep going anyway, to treat the camera as something she could manage, to lean into her authority harder rather than pull back while she still had the option. "This is an official HOA compliance action," she announced, loudly enough for the camera to pick up clearly. "I have full legal authority to be on this property, and I will complete this inspection." Full legal authority, on camera, stated voluntarily, unprompted. I sipped my coffee. Has there ever been a moment in your life when you watched someone choose, in real time, to make everything worse, and you understood, with total clarity, that there was nothing you needed to do except stand still? There's a particular kind of exhaustion that comes not from fighting, but from holding. For 6 weeks, I had carried every piece of this quietly. The legal pad, the manila folders, the county records spread across my dining room table at 11 p.m., the phone calls made in measured tones to people I needed to trust, the patience of watching Karen generate evidence against herself and saying nothing, doing nothing, letting the architecture build itself around her while she mistook my silence for surrender. I want to be honest about what that cost. There were nights, more than a few, when I sat in the chair by the window and looked at my mother's sign beside the garage and felt something that wasn't strategy, just grief. The particular weight of being wronged during the worst week of your life and choosing, deliberately, not to respond the way every instinct tells you to respond. Not because you're afraid, because you've decided that the right outcome matters more than the fast one. My mother was not a patient woman by temperament. She was warm and fierce, and she had strong opinions about casseroles and fence lines and the correct way to store firewood. But she had a phrase she used when I was young and furious about something that felt unfair. A grade, a coach's decision, a friend who had broken a promise. She'd wait until I'd run out of words, and then she'd say, "Let the truth do the heavy lifting, Marcus. You just have to give it enough room." I had given it room. 6 weeks of room. 68 pages of room. 3 witnesses, 1 attorney, 1 detective, 1 news crew, and a door rated for a federal evidence room. Standing on my front step that Tuesday morning, watching Karen Whitfield announce her full legal authority to a camera she hadn't expected, I felt the exhaustion lift in a way that had nothing to do with victory. It was simpler than that. It was the feeling of a structure that has been under load for a long time, finally being allowed to settle into its proper alignment. Not dramatic, not explosive, just correct. Everything in its right place, weight distributed the way it was always meant to be distributed, the design doing exactly what it was built to do. My mother would have found the whole thing deeply satisfying. She also would have had opinions about Karen's blazer. I set my coffee mug on the porch railing, and I let the truth do the heavy lifting. Detective Reyes stepped out from the side of my neighbor's oak tree at 10:14 a.m. She was in plain clothes, dark jacket, badge clipped to her belt, the particular unhurried walk of someone who has already decided how the next 20 minutes will go and finds nothing surprising about any of it. She had a colleague with her, younger, carrying a document folder. The Channel 9 camera was running. Karen was mid-sentence about structural compliance codes when Detective Reyes said, quietly but with complete clarity, "Ms. Whitfield, I'm Detective Reyes, Phoenix Financial Crimes Unit. I need a few minutes of your time." Karen stopped talking. It was the first time I had seen her stop talking without deciding to. She looked at the badge, then at me, then at the camera, then back at Reyes, and I watched her make the calculation in real time, the same calculation people make when they're deciding whether to perform confidence or whether the situation has passed the point where performance is viable. She chose performance, straightened her clipboard, said she was in the middle of an official HOA proceeding and would be happy to speak with the detective at a more appropriate time. Detective Reyes said, "This is the appropriate time." What followed was not dramatic in the way television makes these moments dramatic. There was no shouting, no running, no sudden revelation delivered in a single speech. It was more like a controlled demolition, systematic, sequential, each support point removed in the correct order until the structure had nowhere left to stand. Diana Sousa had joined us by then, walking up the front path with her briefcase, having been parked one street over since 9:30. She stood beside me and said nothing. She didn't need to. Detective Reyes began with the lock modification. She presented Karen with a copy of the Arizona statute, ARS 33-1261, requiring 48 hours written notice before any lock modification on an occupied residential property, except in cases of documented emergency. She presented the management company's written admission that no emergency authorization existed. She presented the violation notice Karen had signed, citing a painted wooden sign as the emergency hazard justification. She asked Karen, calmly, to explain the basis for the emergency classification. Karen said the sign had been a long-standing, unresolved violation. Reyes said, "A long-standing, unresolved decoration is not an emergency under the statute. You signed this authorization. Can you point me to the safety hazard documentation that supported it?" Karen looked at her clipboard. Reyes moved to the fine schedule, presented the board minutes showing the vote had occurred without legal review, with the dissenting board members' recorded objections specifically citing that absence, presented the lien filing, presented Diana's legal analysis, concluding the fine structure was likely unenforceable as applied, asked Karen whether she had consulted HOA legal counsel before applying the fine schedule retroactively to my property. Karen said the board had authority to set fine structures within its governing documents. Reyes said, "That's not what I asked." Then she opened the document folder her colleague was carrying. The property transaction records came out in a single organized stack. 9 properties, chronological, each one a clean narrative. Enforcement campaign begins. Violations escalate. Lien filed. Below market sale closes. Whitfield Property Group acquires. The pattern was visible to anyone standing on that front path in the October morning light. It didn't require explanation. It required only sequence. Karen looked at the stack. For the first time since she'd arrived, she didn't say anything immediately. Reyes gave her a moment, then said, "Ms. Whitfield, Whitfield Property Group LLC is registered in your name. Can you explain your process for ensuring there was no conflict of interest between your role as HOA president and your company's acquisition of properties in this community following enforcement actions you authorized?" The Channel 9 camera was 6 feet away. The microphone was extended. 12 residents of Stonegate Commons had materialized on the sidewalk and neighboring driveways over the preceding 20 minutes. Word travels fast in a neighborhood where one woman has spent 3 years making people afraid, and when the fear lifts suddenly, people come outside. Karen's brother-in-law had already retreated to the Lexus. The man with the crowbar had put it down on my lawn and was studying the middle distance with intense concentration. Karen said, "I don't have to answer these questions here." Reyes said, "You're right, you don't." She gave Karen the case number, the formal investigation notice from the Arizona Department of Real Estate, a business card, and she told her, in the same unhurried tone she'd used throughout, that the Financial Crimes Unit would be in contact within 72 hours to schedule a formal interview, and that she would want to have legal representation present. I had said almost nothing for the entire 20 minutes. I had stood in my doorway with my coffee mug, watching the structure come down the way you watch any controlled demolition, with professional interest and the particular satisfaction of knowing every load-bearing point had been correctly identified in advance. But Karen turned to me then. The clipboard was at her side. The confidence was gone. Not replaced by remorse, not yet, maybe never, but gone nonetheless. She looked at me the way people look when they've finally understood something they should have understood much earlier, and the understanding has arrived too late to be useful. She said, "You planned all of this." I thought about that for a moment. About 6 weeks of legal pads and manila folders and county records and late nights by the window with my mother's sign visible in the porch light. About 19 days left on a lean clock. About a phone call to a news producer and a detective who had been willing to stand behind an oak tree on a Tuesday morning because the paperwork justified it. I said, "No, you planned all of this. I just kept the records in order." Diana touched my arm once, lightly, the way attorneys touch clients when the right thing has been said and there's no need to add to it. 3 minutes later, Karen Whitfield left my property in the back of a patrol car that had been waiting, quietly, 1 block over, since 10 a.m. Her crowbar left a scratch on the door frame. It was the only mark she managed to make. The lien was vacated by the Superior Court 11 days later. The Arizona Department of Real Estate suspended Karen Whitfield's real estate license pending the outcome of the financial crimes investigation. Whitfield Property Group, LLC, was dissolved by court order 4 months after that. The Phoenix Financial Crimes Unit ultimately identified 9 affected households, the same 9 I had mapped on my dining room table with a yellow highlighter and a red pen, and opened formal proceedings against Karen on 7 counts, including fraudulent misrepresentation, abuse of fiduciary position, and predatory acquisition through coercion. Her brother-in-law, David, cooperated with investigators in exchange for reduced exposure. Gerald, the property manager, provided a full accounting of every enforcement action he had processed under Karen's direction. He kept his job. He deserved to. Robert Fenn received a civil settlement that partially offset the below-market loss on his home. It wasn't everything. It was something, and something done publicly, on record, with Karen's name attached to the cause. He called me the evening the settlement was confirmed. We talked for 20 minutes. At the end, he said, "I kept that shoebox for 18 months, not knowing why." I told him he'd always known why. He just needed someone to hand it to. Paul Ochoa was elected to the HOA board in the special election held 3 weeks after Karen's removal. He ran unopposed. The Channel 9 segment aired on a Thursday evening. It was 4 minutes and 30 seconds long. The footage of Karen announcing her full legal authority on my front step, with Detective Reyes standing 10 feet away and a crowbar on the lawn, was the kind of image that doesn't require commentary. The producer used it without narration for 11 seconds. That was the right call. The scratch on my doorframe is still there. I looked at it for a long time the first morning after everything concluded, standing in my own doorway with black coffee and the October light coming in low and clean across the porch. I thought about whether to fill it, sand it, touch up the bronze finish. I decided to leave it, not out of bitterness, not as a monument to anything, but because it's honest. It's the record of a person who came to my home with a crowbar and all the authority she believed she possessed, and left with neither. It's what happens when someone spends years building a system designed to break people and then meets someone who simply kept better records. My mother's sign still hangs beside the garage. Webb family, established 1987, forest green on reclaimed barnwood, level to the millimeter, right where she intended it to be. Some things aren't violations. Some things are just the truth about who you are and what you're carrying. Karen thought changing my locks would break me. What she never understood, what people like her never understand, is that the moment you decide to use power as a weapon against someone who knows how structures fail, you don't start a fight, you start a countdown. The next time someone wrongs you, and every instinct tells you to react immediately, what would it cost you to wait, to watch, to let them finish building the case against themselves?
But here's what this story was really about. It was never about a sign. It was never about a lock, or a fine schedule, or a door rated for a federal evidence room. It was about what happens when someone in a small position of power decides that power is permanent, that no one is paying close enough attention to stop them, that the people beneath them will always choose comfort over confrontation. Karen Whitfield wasn't unusual. That's the uncomfortable part. She was just a version of something most of us have encountered. Someone who found a system, learned its edges, and quietly bent it toward themselves. She wasn't a monster. She was a methodology. And she had been running it successfully for years before she chose the wrong house. That's why she lost. Not because she was evil, because she was careless in the way that people get careless when they've gone unchallenged too long. She stopped checking whether her authority was real or just assumed. She stopped reading the documents she was signing. She stopped considering that the person on the other side of the door might be someone who understood, at a level she never anticipated, exactly how structures fail. She handed a combat engineer her own paperwork and expected him to be overwhelmed by it. She changed a man's locks on the day he buried his mother and expected him to be too broken to respond. She announced her full legal authority on camera, in front of a detective, and expected that confidence alone would hold the frame together. It didn't, because confidence is not documentation, and volume is not a legal argument. Marcus didn't win because he was angrier, or louder, or more aggressive. He won because he was more prepared. He won because he understood something Karen never did, that the most powerful thing you can do when someone wrongs you isn't to react. It's to record, to wait, to let them finish building the case against themselves while they still believe they're winning. His mother told him, "Let the truth do the heavy lifting. You just have to give it enough room." That is the whole lesson, right there. Most people have met some version of Karen Whitfield. Maybe not in an HOA. Maybe at work. Maybe in a landlord situation, a neighborhood dispute, a family dynamic, a workplace policy that one person seemed to bend in only one direction. Someone who used process as a weapon and counted on you being too exhausted, too uncertain, or too alone to push back. And the question that stays with me, the one I keep coming back to, is this. At what point would you have stopped documenting and just fought back? Because Marcus held for 6 weeks. 6 weeks of watching someone escalate, generate paper, announce herself on camera, file a lien against his home, and he held. Most people break much earlier than that. Most people confront too soon, or fold too fast, or both. I'm genuinely curious where your line is. Drop it in the comments. There's no wrong answer. And honestly, some of the most interesting conversations I've had have started with that exact question. If you're drawn to stories about quiet preparation beating loud authority, about people who understand systems deeply enough to let those systems work, there's more coming. I'll see you in the next one.